no, they don't understand what it is. So please pay attention. When I say entrenchment clause, entrenchment word means to provide additional safeguard or to provide additional security. So basically, guys, how is any decision taken? So let's say I tell you, today I'm going to teach you till 5 in the evening. So let's do a vote. Those in favor, raise your hands. I'm raising hands in favor of everyone. Oh my God, I have people. I thought no one will vote. I have 2 votes. And obviously I am there. How many of you, the class should end here and now? Your vote is rejected. So anyway, so any decision, how does a company come to a decision? So basically, the decision of the company is known as what? Resolution. And generally what happens is, we have this very simple concept. If the votes in favor is more than votes against, right? Can I say the resolution is passed? Yes. This is known as what? Ordinary resolution. And what is ordinary resolution? More than 50%. Ma'am, 10 people, more than 5, 5.5. Please. But what happens because of this is, let us say, if you remember, I told you when the voting is done by poll, you have 1 share, 1 vote. Am I right? So this is this 49% and that was 51%. Okay? So can I say these 2 people together, they have 51% of votes? Yes. Now, whenever company would call a meeting, what these guys would do, no, this 51%, they would always come together and they will decide, acha, let's do this vote. And when they go to the meeting, they will vote like that. So can I say, isn't it that this 51% is always making the decision? 49%, ma'am, they are making, no. 51% jo chayega, if my vote is in sync with their vote, then okay. Otherwise, whatever the 51% is deciding, that is only happening. So, with that in mind, the lawmakers said that we should have a concept of special resolution. So, what is special? Ordinary is simple. Votes in favor is more than votes against. What is special resolution? Votes in favor is at least 3 times votes against. Is at least what? 3 times votes against. This is known as what? Special res. That means, can I say here it is minimum 75% in favor. So let us say we have 12 people voting. How many I need in favor? Minimum 9 I need in favor, right? This is special resolution. I hope you have understood it. Yes. So if I want to alter my articles, I have to pass special resolution. This is not something that I am saying. Law says. So law says we can have ordinary, we can have special. But where we will have ordinary and where we will have special is not decided by the company. Who decides it? It is decided by the lawmakers. Companies Act says. So section 14 of Companies Act, which talks about alteration of AOA, talks about the concept of alteration of AOA, where it says to alter my AOA, I need to pass which resolution? Special resolution. Yahan tak sabko samajh mein aaya. Yes? Fine. Now this Mr. Stupid, he started a company. And he was holding how many shares? 99%. And obviously his company will have what? Articles of... No, it will not have stupid. So lot of provisions was there. One provision in the articles was One provision in the articles was Mr. A will be kya? Chairman for life. And other provisions. Now, if I want to remove this provision from the articles, can I say that would be alteration? Yes. And for alteration, which resolution? Special. Fine. Dheere dheere, his business was doing great. His business was doing amazing. So what happened was he started giving up shares, more shares to the public. Now happened one tension. What? His holdings came down to 50%. Now he got worried. Why he got worried? That in this case, if in the already 50% is in the market, another 25% shares goes in the market, that 75% can remove me from the chairmanship. Correct or not? So he was like, I started the company and they can remove me anytime, because the moment 75% shares is in the market, they can actually alter this AOA. Correct or not? So he got very worried. So that day he decided on two things. What two things he decided? He was like, whatever happens, I will always hold minimum 10%. Well, 10% of the share capital will always be mine. I can do that. Reliance, more than 50% is held by Ambani's, right? They can always manage. Whenever we bring a further issue or something, we will take up some of the shares. Matlab, that minimum 10% I will always maintain. So, ma'am, what happens with this? Second, what he did, in this clause, he added one point. To alter this clause, we will need consent of what? 95%. What he did? To alter this clause, I will need consent of what? 95%. Now, if he has minimum 10% holding, can we now get 95% here? No. When I add this, something like this, it is known as what? Entrenchment clause. When I add something like this in my articles, it is known as what? So what is entrenchment clause? To provide that a particular clause of the articles can only be altered by provisions which are more strict than special resolution. That means I have provided that a particular, not the whole articles, a particular clause of the article will be altered only by provisions more strict than or special resolution. So, if here I say this clause will be altered by 60% consent, will it be valid? No. Why not? No. Because it has to be more strict than special resolution. Special resolution is 75%, so it has to be more than that. So, by doing this, what I have done is, the rest of my articles will be altered only by what? Special. But this clause will be altered only by, this is known as what? Entrenchment clause. Is it clear to all of you? Is it clear to everyone? So what it means is that a particular clause of the articles can only be altered by provisions which are more strict than the special resolution. I hope it's clear to everyone. Yes? I want your attention here, all of you. How can I add this clause? At the time of incorporation, can I add this clause? Yes. Can I add this clause at the time of incorporation? Yes. But did A put this clause at the time of incorporation? No. So can he add it later also? Yes. When you add or remove something from your articles later, this is what? amendment or alteration. So can you add the clause as an alteration? Yes. See, alter AOA. Yes. So can you add the clause later after incorporation as an alteration? Yes. To alter my articles, which consent I need? Special reason. But guys, if I am a private company and I want to alter my articles to add an entrenchment clause, I need consent of all. Wait, if I'm a private company, I want to alter my articles, which consent I need? Special resolution. But if I am a private company and I want to alter my articles to add entrenchment clause, for that I need which consent? All. Pata hai, in Companies Act, there are only two cases where consent of all is needed. One is this, one is section 96. Otherwise, it's always what? Special resolution or entrenchment, whatever. Is it clear to everyone? So I can add this clause either at the time of incorporation or I can alter my AOA and add it later. If I alter my AOA, public company will alter by special resolution. But if a private company wants to alter AOA to add entrenchment clause, it needs the consent of all. Now, whether it is at the time of incorporation or whether it is at the time of alteration, doesn't matter. Notice of entrenchment clause must be given to whom? To the registrar. I hope this is clear to all of you. Yes, we are done with entrenchment clause. Please make a note of this before we go forward.